Counsel, ready to proceed? How much time do you want to reserve, if any?
5 minutes, Your Honor.
You got it. You may begin, sir.
May it please the Court. For the last 15 years, this Court has been at the forefront of interpreting procedural and jurisdictional issues relative to exceptional student education due process hearings. In 1992, in District School Board of Putnam County versus Roderick, the Court held, in summary, if a party elects to take a case under Section 230.23(4)(m)(5) to the Circuit Court, the case will receive a de novo review. If the party elects to bypass the Circuit Court and take the case to the Appellate Court, the case will receive additional appellate review.
It seems to me like all you did was litigate all these ancillary matters and bypass basically a hearing on the merits. I mean, it seems to me like your clients were concerned about the fact that they set a hearing without consulting with them first. That was litigated. It went back and forth on all these ancillary issues. When really, it seems to me like you should have concentrated on just having a hearing on the merits. Well, did you ever have a hearing on the merits?
We haven't, no. And in fact, Your Honor, what my clients are concerned about is having a fair and impartial hearing. They have a right to have a fair and impartial hearing, both under the federal law, under the IDEA, and under state law. And their contention has been, and continues to be, that the Division of Administrative Hearings is incapable of conducting a fair and impartial hearing in this matter.
Why?
And because they, and this was addressed within our brief, but it is our contention that, one, they apply the improper standard, that the relative to the provision of a free appropriate public education, that they apply the Raleigh standard from the U.S. Supreme Court, which is something more than de minimis educational benefit standard, when in fact Florida has adopted within Article 9, Section 1 of the Florida Constitution a high quality standard. Now, again, addressed in our brief, in our case before you, in the Simon case, you determined that that was not a self-authorizing provision.
But let me stop you for a second.
Okay.
So isn't that the equivalent of saying, my case has been assigned to Judge Smith. Judge Smith has a history of being plaintiff-oriented or defense-oriented, and therefore I want to, I think I ought to bypass Judge Smith, even though I don't have a grounds for recusal for him. Isn't that essentially what you're saying? I don't like the way Judge Smith rules, so I'm going to bypass that process.
And our argument is broader than that. We're not talking about Judge Smith. We're talking about DOA in its entirety, and we're not talking succinctly just about the ability to apply the appropriate standard. But we have administrative.
Well, who's supposed to conduct the hearing then? If you don't want any of the hearing officers, you're not satisfied with any of them. Any of them are going to be fair and impartial. Who's supposed to do it?
Well, under 120.80, there is a provision that says how that's supposed to occur. Now, I think rather the appellees in this instance have really narrowed their argument, and this is what I would like to address, is that 120.80 requires that the hearing before DOA come before them under 125.69 or 120.57, and that because our proceeding came before under 120.57.5, that that 120.80 is inapplicable. And I think that that's I don't think that that's specifically what the statute says, but as I addressed in our brief, I think even if it does say that, then the issue is that DOA then inappropriately handled our case whenever it came in, when the administrative law judge said, I don't have jurisdictional authority here because the case is pending before the administrative commission, instead of coming in and treating the case in a manner that was consistent with the AKW case. And quite frankly, that's part of the problem here, is that these cases, because they arise under the individual school boards are not reported cases.
So here, who's supposed to conduct the merits hearing?
If the
You're saying DOA's out. I mean, they're not there and they're not going to be involved.
okay, under 120.80, then the administration commission then comes in and appoints an attorney to act as the administrative law judge.
Counsel, let me ask you what I think is the threshold issue of this case. I don't think that you can argue that DOA is a proper party to a Section 1003573 action. Would you concede that? I don't think DOA is a proper party to it. And if that's the case, then how does DOA get jurisdiction to appoint an attorney to act as a hearing officer?
Well, and I would not agree with that. No, I would not concede that fact. And in fact, beyond DOA, the additional respondents, and I currently have a case that's where we have also alleged that the Department of Education has a respondent. Both the W case, which was a district court case, and the Babbage case, which is an 11th Circuit case, both say that before the parents, before a party, and in this instance it's primarily the parents, can proceed onto a subsequent review and subsequent forum, that they have to exhaust their administrative remedy, both from an issue standpoint and equally from a party standpoint. The W case makes that quite clear, that it was remanded back to DOA to allow the W's to be able to come in and to include the Florida Department of Education as a party, and Babbage requires that. So from a parent standpoint, you have a catch-22 situation if you say that 1,357 does not permit parents to be able to add additional parties, then how are they to exhaust their administrative remedies? And I think that that from the perspective that the enabling statute under 1,357 does not preclude a parent.
Here's what 12052.12a defines, and this is, I think, the argument that DOA is essentially making, defines a party as a specifically named person or persons whose substantial interests are being determined in the proceeding. What substantial interests does DOA have in these proceedings? They're not the parent, they're not a school board, they're the entity that's supposed to conduct the merits hearing. What interest do they have that would make them a party?
Well, under 6A603311, at the time that this case was at issue, paragraph 5 and now is paragraph 11, DOA has duties under that particular rule. So within the conformity of those duties, DOA is a party, and DOA has responsibilities and duties.
But DOA is a party, but is it a proper party? That's you're arguing it's a party. You made them a party by putting their name on a complaint.
Well, what I'm before you today to ask you to do, I think, is, and again, this goes back to what I initially started to say, is that because all of the ALJs are at equal procedural height, there is no stare decisis in these cases. These cases
is not, because I don't think the legislature ever contemplated this.
Well, and I think that
I
going
mean,
back
they never thought about a situation like this. I mean, you have to show that they have a substantial interest to make them a party, and that's going to be determined in the proceedings. That's not DOA. All DOA is supposed to do is provide you with a hearing officer.
DOA is supposed to, but under the rule, DOA is supposed to conduct a fair and impartial hearing, and if the
But if they don't, you can appeal.
And under your decision in Roderick, if they don't, we can move to the circuit court and we can obtain a trial de novo.
Well, have you already filed a circuit court complaint?
We have.
Well, why isn't this case mooted anyway?
And I have asked you, I have addressed the moot issue, and I have said that I believe that this is an issue of great public importance, and I've asked you to be, and that it's likely to occur again, and that you need to
Since
come
it's
in.
never occurred in the history of the state before, why would it likely occur again?
Well, the order in this case addressed three parties, and only one of which was willing to come into appeal. But if the court's decision is that 1,357 does not allow the parents to be able to add an additional party other than their school district, where Babbage says that they have to add, if they are going to proceed to federal court, that they have to add an additional party, then that decision is greater than just DOA, because many times in these cases the Florida Department of Education is added as a party. So in this instance where perhaps DOA has not been added as an additional party, very frequently the Florida Department of Education is added as a party. And so the scope of this, if it's the court's inclination to come in and say that 1,357 does not contemplate suits against any party other than the school board in these cases, then that's going to have a severe limiting effect, both in terms of the
I would think at a minimum it would have to be somebody that has a substantial interest that's going to be determined by the proceedings. That doesn't seem to me to place DOA in that category.
Well, I think the better procedure here, and what I am encouraging the court to adopt, here's what I think would be the appropriate resolution of this case, is for the court to come in and to adopt ALJ Hickson's opinion in the AKW case, which I cited to you, where ALJ Hickson came in, looked at a case brought by the W's that subsequent to the district court, the federal district court's remand, and said, I now have this case before me that includes the Florida Department of Education. It does not appear to be an appropriate case or party under 1,357. So instead, what I'm going to do is I'm going to treat that case as if it is a request for a formal administrative proceeding pursuant to 120-569 or 120-57, so that in these cases, whenever a parent comes in and in order to exhaust its administrative remedies, it has to bring a case against all parties within the provision of this statutory scheme, that then DOA has direction from this court as to how they're going to handle this. That's the issue here, is DOA, whenever DOA receives a request for a due process hearing from a school board that includes a party other than, in addition to, the school board itself, if it includes the Florida Department of Education or vocational rehabilitative services or some other additional respondent whom the parents believe may have a liability relative to this issue, DOA does not, on a consistent basis, know how to handle those. And that's clearly evident in the difference in the treatment within our case and in the AKW case. In the AKW case, the administrative law judge came in and said, I've got the Florida Department of Education as a party. That's not the typical kind of request for due process hearing, exceptional student education request for due process hearing that I get. How am I going to treat that? How am I going to treat FDOE? And in that instance, he came in and he treated it, as I said, as a request.
Let me ask you this: if we were to affirm, would you be out your right to have an administrative hearing on the merits now, because all this time has gone by and all the legal maneuvering?
Well,
and that sort of thing?
and I'm approaching my 5-minute clock, and one of the nice things about getting here early is that you get to see how this works. But to answer your question, is we have proceeded in circuit court.
Well, let's say I'm not saying how we're going to rule, but for example, we affirm. Where do you go from there?
We're already in circuit court, and we're already there under the futility doctrine. And so, because we've attempted to exhaust our administrative remedy, have, during the period of time, as I indicated in the brief, from the time that we requested the hearing before the, well, in the time from when we requested that the Administration Commission.
So what are you requesting in this? I mean, I'm just curious. What are you requesting in the circuit court? You said the futility doctrine. You're saying it was futile to pursue your administrative remedy. So you want now what, a hearing before a lawyer?
No. What we have, again,
so you're asking,
again, under this court's decision within Roderick, we have the ability to come in and to have a trial de novo. So what we have,
okay, you're asking the circuit court for trial de novo before the circuit court.
yes.
Okay.
But that doesn't clarify how these cases are supposed to be handled. And again, they're being handled on an inconsistent basis, and the parents of disabled children, in the same way that this court has made decisions relative to these issues and has taken a lead position.
You're down there.
I'll,
You may proceed, sir.
May it please the Court, Your Honor. My name is Andrew Thomas. I'm appearing as counsel for the Citrus County School Board. The school board's interest is in seeing a prompt determination of the adequacy of the educational program that it offers students. Normally, that's also the parents' interest. Of course, all of us want to see the dispute decided by an impartial tribunal in accordance with applicable law. That can be done in a case like this. Section 1003.575 allows, for example, if there's a concern about the partiality of the administrative law judge, separate statutes allow for a motion to recuse that judge. If the law is wrongfully applied, as Mr. Boswell claims, though administrative law judges are inclined to do, then the remedy is through the appeal process or the de novo review or whatever. So there are ample opportunities for these matters to be brought before an impartial body. Our argument is pretty straightforward. Section 1003.575 states, really in the most absolute terms possible, that administrative hearings dealing with, very limited in scope, dealing with the identification, evaluation, and placement or lack thereof of a public school student must, statutory language, must be conducted by an ALJ from the Division of Administrative Hearings. As I believe you correctly surmised during your previous questioning, an administrative law judge, in fact, the Division of Administrative Hearings, does not play any role in the identification, evaluation, or placement of an exceptional education student, other than as a trier of fact or a tribunal to resolve the issue. So I believe that if the court looks at the underlying purpose of these statutes dealing with resolution of disputes between school districts and parents regarding the education of their children, the conclusion is that the legislature has clearly established a process for doing that. And that process is through the administrative law judge first, and then with an extraordinary number of avenues of review or appeal thereafter. That's all we're seeking. We'd like to get this promptly resolved, and clearly the school board has interest in seeing this promptly resolved. We want to see the merits promptly decided.
Thank you very much.
I think the issue here again is one of continuity, and that is that when the Division of Administrative Hearings receives a request for an exceptional student due process hearing that includes a respondent other than a school board, those cases are not being handled consistently, and it's a luck of the draw. As indicated in the AKW case, in that instance, ALJ Hickson made the determination that that under 1003-57, that the Florida Department of Education was not an appropriate party under that case, and then made the decision to handle that case as if it were a request under 125-69 or 120-57. In our case, the ALJ did not make that decision. In our case, the ALJ came in and said there is concurrently pending that this case is pending before the Administration Commission, and so therefore I am stripped of my jurisdictional authority over this case in its entirety, not just over the Division of Administrative Hearings as a party. Now, for 8 years, I have been promoting Roderick as the ability of parents who have an adverse action against them, for them to be able to come in and to take that action for a trial de novo, consistent with this court's decision within circuit court. The problem is,
if you had found an administrative hearing officer that was fair and impartial, would you still be able to make the same argument? I mean, you know he was fair and impartial, and you know that was not an issue.
but I don't think that's the legal issue that's pending before you. I think the legal issue.
But if you found a hearing officer that you thought was fair and impartial, or if there was an argument that could not be made that he was not fair and impartial, would you still be able to make the same argument that you're making here today? Or would your avenue of appropriate procedure be to go to a hearing before that hearing officer?
And I think that may address the issue relative to DOA, but I don't think that addresses the issue of how the Division of Administrative Hearings is supposed to handle a request for due process hearing that includes someone in addition to the local school board. If it includes the Florida Department of Education, if it includes vocational rehabilitative services, and so the issue here is broader than just whether or not the parties may appropriately believe that the administrative law judge is not fair and impartial. The broader issue, as addressed by the appellees, and basically on their part, it's a tipsy horseman argument, because the Administrative Commission did not make the determination that it lacked subject matter jurisdiction over this issue under 120.80 because the case did not arise under 120.569 or 120.57. They made the decision that they did not have subject matter jurisdiction under other issues. But the unanswered question here is what happens in these cases when there is an additional respondent to just the local school board. How is DOA supposed to handle that? And what I've demonstrated to you is that it's only handled. So
you're saying it's a matter of law that DOA doesn't have jurisdiction over any of these other parties. I mean, they're just you have to find some other way to handle them.
I'm saying that it's being handled inconsistently, and perhaps under one. I don't think that 1,357 is read that narrowly. But if you do read it that narrowly, because W and Babich say that to be able to proceed further in the review process within the federal district court, you have to have first exhausted your administrative remedies both towards issue and towards parties. Parents have to have some vehicle by which they exhaust their administrative remedy. Now, what I equally have cited to you is that it is contrary to the court's decision within Roderick that says that a adversely affected party has the right to a trial de novo before a subsequent party. Yes.
Thank you both very much.
Thank you.